A part dedicated the matter of Phones for You Limited and EE Limited and others.
Yes.
May it please the court. May I start with a very brief recap on where we were supposed to play yesterday in relation to modelling.
Yes.
And the court will recall that we saw that EE's modelling changed sharply on the 5th of May. Mr. Ayer's evidence, he who was responsible for the modelling, was that the assumptions made on the 5th of May, particularly as regards the handset cost efficiencies, could only make sense on the basis that following his conversations with Messrs. Alera and Milson, he was inputting into the modelling an assumption that Phones for You would materially exit the market. Now, the judge didn't refer to that evidence as to what assumptions were reflected in his modelling of the 5th. We did not allege that Mr. Ayer was in the colluders' circle. And we don't allege any collusive knowledge on his part in relation to the detailed way in which he accommodated the assumption about Phones for You going out of business in his modelling. The critical point, though, from our perspective and in our submission, was that for the first time on the 5th of May, following his conversation with Milson and Alera, but before the cash flow analysis, which the judge referred to on the 8th of May 2014, Ayer's modelling assumed a step change, both in relation to absorption assumptions, but most importantly, in relation to the handset cost efficiencies. And I think
I'm not, it may be me being slow. I don't know why you're saying it's more, the handset cost efficiency point is more.
It's more important because it is only, the handset cost efficiencies are contingent on either Phones for You not being in the market at all or being a materially reduced presence in the market.
But isn't the absorption rate also?
Yes, it is. The absorption rate.
I don't really understand the distinction.
Well, you can't get handset cost efficiencies at all without Phones for You being a materially reduced presence. That's the evidence of Mr. Ray. As far as the absorption assumptions, I showed the court yesterday that in April they were assuming a 25% absorption if they exited from Phones for You. By the time we get to the 5th of May, it's rather more dramatic. 60%, 70%, or whatever the figure is. It's much more dramatic. But the point is, you don't get handset cost efficiencies unless Phones for You is out of the market. And I showed the court yesterday.
So just picking up on my lady's point, really.
Yes.
The absorption rate doesn't go as far as Phones for You being out of the market completely.
Well, it may or it may not.
It may or may not, but
Yes.
you say the handset cost efficiency does.
Yes, and that is the evidence which was given by Mr. Ayer. Perhaps I could just remind the court of that,
Thank you.
which is in Supplemental Bundle 1, Tab 4, at paragraph 58, which is the long paragraph. It starts at page 106.
Yes.
But I want to go over to 108, Roman 4 on 108. Although I can't recall this, the inclusion in the draft modelling for scenario 1 of handset cost efficiency of 34 million per annum might have reflected a provisional view following discussions with Alera and Milson that Phones for You were likely to represent a significantly reduced presence in the market following withdrawal. Brackets, and this is the important bit, because EE could not otherwise, in my view, have realised handset cost efficiencies of this scale. Yeah. I mean, we say that the same is true of the assumptions, but we don't have as stark evidence from Mr. Ayer, the modeller, that these assumptions, this particular assumption, only makes sense on the basis that Phones for You was a reduced presence in the market.
Thank you.
Yeah.
Now, I was going to show the court, and I think I may have already done this, stop me if I have, what the judge said about this at paragraph 522 of his judgment, Core Bundle 1, Tab 18, page 409.
Yeah.
Now, the judge simply doesn't deal with Mr Eyre's evidence that these handset cost efficiencies only made sense on the 5th of May on the basis that Phones for You represented a significantly or non-presence in the market. It doesn't matter from Phones for You's perspective as to the timing that Mr Eyre himself thought was the position. The assumption of handset cost efficiencies, as he has said himself, and the judge ignored, is that that was only consistent with Phones for You not being a significant presence in the market. And it is entirely consistent with our case that it was following his discussions with Messrs Milsom and Valera on the 28th and 29th of April that these new assumptions were being made.
You said stop you if you did it yesterday, and according to my note you did.
My lord, I will move on.
Yeah. I think my lord asked you whether the point was that overlooked detailed evidence in chief.
Yes, I'll move on.
Yeah.
Can I show the court what the learned judge said in his permission judgment, refusing permission, core bundle 2, tab 19, at page 476 of the bundle.
Yeah.
And invite the court to read paragraph 48, where it's dealing with this. So,
Yeah.
now, the point is, whether or not the judge was accepting or not accepting Mr Eyre's evidence about what it was that led to the modelling assumption changes, what he did not deal with is Mr Eyre's evidence that it was on the 5th of May for the first time that the modelling assumptions were assuming that Phones for You was going out of the market. And that's the important point from this perspective. So the judge actually, the judge's reasons for refusing permission actually give no explanation as to why Mr Eyre was making this modelling assumption as early as the 5th of May. The judge's conclusion, as you see in paragraph 521, I've shown you already, was that it was some cash flow analysis that led to a dramatic change. But in fact, we know as Mr Eyre's evidence, which the judge didn't deal with, it was actually earlier.
Yeah.
So the critical factor wasn't the quality of the recollection of Mr Eyre as to his discussions with Milsom and Valera, but rather that the assumption was in fact made at that time. Now, as far as EE is concerned, in its skeleton argument, I showed you yesterday the closing submissions where EE said, yes, the modelling assumptions changed on the 5th of May. The court will recollect that. Now, on appeal, departing from that position, they now row in behind the judge and say that the modelling assumptions changed on the 12th of May. That's in there. We don't need to turn it up. That's paragraph 71 of their skeleton argument. They point out that it was only in the modelling of the 12th of May that an exit from Phones for You came to be projected as substantially profitable. Correct, but neither here nor there. The crucial issue before the court is the timing of the change to make assumptions that which were premised on Phones for You being in either non-existent or substantially reduced presence on the market. The two, of course, are linked, but it was what Mr Eyre was asked to assume about Phones for You's survival that mattered. E, as rowing in behind the judge, also focuses on certain documents which suggest that Mr Eyre personally thought what was likely to happen following an exit. And they understandably take their lead from judgment paragraph 522, which we've looked at. But that misses the point. As I've said, Phones for You did not suggest that Mr Eyre was privy to collusive information. The full thrust of our case was that it was following his meeting with Milsom and Valera that there was a dramatic change in the modelling. So we submit that this is a prime example of critical evidence having been ignored by the learned trial judge, which could have made a material difference if it had been properly appreciated. Now that leaves one further sub-point under ground 4, which I'm going to address under my ground 5, which is the ground where we contend that the learned judge approached this as adopting a compartmentalisation. Exactly. We refer in our skeleton to the judgment of Lord Steyne in Smith New Court. We don't need to turn it up. The court is no doubt very familiar with it. On analysis in our submission, the compartmentalisation.
It's not an easy word, is it?
It's not an easy word, my friend, at this time of the morning. Both compartmentalisation and ground 4 are, in our submission, closely linked in a case where there has been a substantial delay. And indeed, if one looks at the St. Petersburg case, one sees that particular point is made by the learned then Chancellor.
Yes, I recall that.
Yeah. Now, it's fair to say, when we raised this compartmentalisation point with the learned judge, his response was robust. And he described it as a misconceived attack on how he had decided to structure his judgment. And that's what he says in paragraph 52 of the permission judgment, full bundle 2, tab 19476. However, the learned judge rejected the suggestion that he'd effectively made provisional findings on some of the evidence before then turning to consider other evidence to see whether it could dislodge that finding. But in at least one instance I'm going to show the court, I'm afraid, in our submission, there's simply no other way of reading the judgment. And with due respect to the learned judge, it is clear that in certain important aspects, he disregarded in one part of the judgment matters that he'd addressed in another. Now, 2 of the 3 topics covered by ground 5 were dealt with in the judge at the back end of the judgment in his section entitled A Series of Unfortunate Events.
Yeah.
But the first point is the rejection of the point which I've already addressed under ground 4, but it also comes into ground 5. And that's the point that we asserted that Mr Dunn made the same anti-competitive approach to Mr Swanty to Mr Lawrence. Now, as I say, I've already addressed this partly under ground 4, and I referred the court yesterday to the Evans text message of, I think, the 2nd of January 2013, and to an extract from the slide deck, which assumed that Vodafone would follow O2. I don't retract at all our submission. We say that the evidence, the inherent probabilities, and the evidence I've shown the court present a compelling case for the inherent probability that Dunn also raised with Lawrence precisely the same topic as he approached Mr Swanty with. But the judge, in considering the inherent probabilities in our submission, disregarded his own assessment of the evidence, which showed the very close link between the topic of supplies to indirect retailers on the one hand and the question of 4G pricing on the other. That close link was important because the judge found that Dunn colluded with Lawrence in relation to EE's pricing, but he dismissed the relevance of that collusion as to the question of Dunn and Lawrence colluding about indirect distribution. We obviously say that even if the topics were unrelated, which they were not, the willingness of Dunn and Lawrence to collude, and Dunn's incentive to collude with Vodafone, just like with EE, on indirects, added up to a strong inherent probability that Dunn would have approached Lawrence about indirect distribution in the same way as he approached Swanty. But the 2 topics were very closely related and essentially, in our submission, aspects of a single issue. In our submission, it's close to inconceivable that Dunn approached Lawrence.
Attention, please. Attention, please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run.
It's not a test.
Do not use the lifts. Follow the instructions of fire evacuation officers.
I'm sorry, there've been a lot of the thing last week, the week before, there was an incident which sent out to the false alarm.
Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now